Imagine you are the victim of a massive multi-million-dollar heist. You have all the bank records proving exactly where the money went.
Right. Every single receipt.
Exactly. You have a meticulously documented flowchart showing the names of the thieves who drove the getaway car and, who fenced the stolen goods.
The whole operation mapped out.
Yeah. And you walk into a federal courthouse, drop that massive box of undeniable evidence right onto the judge's desk, and the judge looks at you and says, I am not going to look at a single page of that.
Wow. Just completely shuts you down.
Right. The judge says because you didn't legally have the right to find it before this trial began, you are told to just pack up your evidence and leave.
Well, the people who robbed you are basically free to go out and do it again tomorrow.
Exactly. And today we are looking at how the legal capital of the world might have accidentally legalized a billion-dollar fraud machine.
It's just the ultimate legal catch-22. I mean,
Yeah.
You need the evidence to be allowed inside the courthouse.
Right.
But the only way to actually get that evidence is by being allowed inside the courthouse in the first place.
It makes no sense.
No, it doesn't. And what makes this so incredibly vital to understand is that we aren't talking about some, hypothetical law school scenario. This is happening right now.
Real cases.
Real cases involving just astronomical sums of money.
Well, welcome to the deep dive. And I want to note right at the top for you listening, this is a special extended deep dive. We are going to be here for a while.
Yeah, there's a lot to unpack.
There really is. The severity and the potential consequences of what we're looking at today just demand that we take our time. So we are looking at a stack of incredibly dense legal documents.
Mostly focusing on two massive federal court decisions.
Right. Two decisions that were issued on the exact same day, August 14th, 2026. And alongside those, we have a couple of legal analysis memos and this really sharp op-ed by Damian J. Caldwell.
Caldwell's piece is fascinating.
It is. And what all of this source material reveals is a glaring, just massive geographic anomaly in the United States justice system.
It is an anomaly that fundamentally alters how fraud is prosecuted in this country. I mean, we are going to explore why a specific type of organized fraud case.
The really sprawling kind.
Exactly. The kind of massive conspiracy you would expect to see in a mafia documentary. Why that kind of case is allowed to proceed normally in states like Pennsylvania and California, but gets completely and utterly shut down the minute it crosses into the federal courts of New York.
It's wild. And before we get into the weeds of all these federal legal standards, we really need to establish the stakes. Like, why are we spending an hour on this?
Right. Why should anyone care?
Exactly. If you don't work in insurance or corporate law, why should you, the listener, care about this jurisdictional quirk?
Well, it matters because this is about a multi-billion-dollar slip, trip, and sue industry.
Yeah.
This is an alleged industrial-scale assembly line of fraud, and it drives up the insurance premiums that you pay.
For everything.
Right, for your car, your home, your business. When these massive enterprises drain billions of dollars from the system, those losses don't just, vanish into the ether.
They get passed down to us.
Every single consumer pays for it.
That's great.
If the federal courts in New York, which is, one of the financial and legal hubs of the entire globe.
Arguably the biggest?
Right. If they're effectively closing their doors to these specific types of fraud cases, it creates a massive safe harbor.
A protected zone.
Yes, a protected zone for exploitation that impacts the entire national economy.
So let's lay out the source material we are working with here. We are pulling from two major federal civil ARCO lawsuits.
Rico being the racketeering statute.
Exactly. One was filed by Uber Technologies, and the other was filed by Union Mutual Fire Insurance Company. Both of these plaintiffs attempted to take down sprawling networks of alleged fraud.
And both were dismissed on the same day in the Eastern District of New York.
Right. And to help us contextualize the environment surrounding those dismissals, we have Caldwell's op-ed. He deeply analyzes the political and cultural atmosphere of the New York judiciary.
Which is really important context. But the best place to start is by looking at the machine itself.
The fraud machine.
Right. To understand why these legal decisions are so mind-bending, we first have to understand the sheer scale of the enterprise that Uber and Union Mutual are alleging.
Because we are not talking about, like, someone slipping on a wet floor in a supermarket and exaggerating a knee injury to get a quick $5,000.
Yeah, not at all.
When I was reading through the Union Mutual complaint, the level of organization described is just staggering. If we assume the allegations are true, which, by the way, is what a judge is legally supposed to do at the beginning of a lawsuit, this is a highly coordinated operation.
It really is. The complaint actually breaks down the participants into distinct categories. It looks almost like a corporate org chart.
Okay, let's walk through that chart. First, you have what they call the runner defendants.
Yeah, the runners are essentially the ground game of the operation. According to the court filings, these are the recruiters. They actively seek out the claimants.
And the demographic targeting here is deeply concerning, right?
It's awful. The allegations state that runners specifically target vulnerable populations, non-English speakers,
Yeah.
individuals living below the poverty line.
People who might be struggling with housing insecurity.
Exactly. People who are just desperate for an immediate influx of cash.
And the complaint outlines that these runners are doing two distinct things. Sometimes they find people who have been in legitimate but incredibly minor accidents.
Like a tiny fender bender in an Uber.
Right, where no one was actually hurt. But other times, they are allegedly coaching people to completely stage an accident.
Just making it up entirely.
Yeah, like they will orchestrate a fake trip and fall on a commercial construction site, for example.
And once the runner has the individual to claim it, they don't just send them to, a random hospital.
No, they have a system.
Right. The runner's job is to funnel that person directly into the next tier of the enterprise.
The legal service defendants.
The lawyers.
Yeah.
And the Union Mutual complaint specifically names prominent New York personal injury firms. Firms like the Subin firm, Wingate, and Benilov.
Yes.
Now, I want to pause here because this is where the flowchart starts to look less like a series of independent actors and more like a syndicate, like a movie production.
That's a good way to look at it, right?
Right. What is the alleged role of these law firms? Because lawyers are bound by incredibly strict ethical boards. If a law firm is taking a case where they know the accident was staged, aren't they risking immediate disbarment?
That is the crux of the allegation. The plaintiffs claim that the law firms are not merely representing injured clients. They are the orchestrators of the entire narrative. They are the directors of your movie analogy.
Wow.
The allegation is that the law firms directs the runners on who to recruit. And once the claimant is brought in, the law firm completely manages the medical journey.
They tell them what doctors to see. Exactly. They allegedly tell the claimant exactly which specific doctors to see, in what order, and they orchestrate a very specific regimen of care.
And that care is designed solely to maximize the financial value of the eventual lawsuit.
Precisely. Which brings us to the third group.
And honestly, this is the part of the source material that I found the most disturbing. The medical provider defendants. We are talking about named, licensed medical professionals here.
Real doctors.
Yeah, doctors like Michael Gerling and Leonid Reifman are explicitly named in these documents.
To understand why the medical providers are so central to this alleged scheme, we have to talk about how New York insurance law works, specifically the no-fault law.
Okay, break that down for us.
In New York, if you are in a minor auto accident, your basic medical bills and your lost wages are covered by no-fault insurance, regardless of who actually caused the accident.
That sounds reasonable.
It is, but that coverage is capped. You cannot sue the other party for massive pain and suffering payouts unless you cross a very specific legal threshold.
Meaning you can't just sue for anything.
Right. You have to prove you sustained a quote-unquote serious injury.
So a sprained ankle or a bruised back doesn't get you $1 million lawsuit.
Exactly. Soft tissue injuries don't cross the threshold. But you know what does cross the threshold?
Surgery.
Surgery. A permanent alteration of the body. And this is where the medical providers come in. The lawsuits allege that these doctors provide deliberately false diagnoses.
Oh.
Yeah. They will take a patient who has normal, age-related degeneration in their spine, something practically everyone over the age of 40 has.
Right, just normal wear and tear.
And they will falsely document it as acute catastrophic trauma caused by that minor fender bender.
But the allegations go way beyond just fudging the paperwork, don't they? They allege that these doctors are performing medically unnecessary treatments.
Invasive procedures, yeah.
We are talking about lumbar discectomies, spinal fusions.
It's terrifying.
They are allegedly cutting vulnerable people open and fusing the vertebrae together when they do not need it, entirely to artificially manufacture that serious injury threshold so the lawyers can demand a massive payout.
It is a profound violation of the Hippocratic Oath, if true. The physical toll on the claimants is irreversible.
They have to live with that surgery forever.
Right. But from the perspective of the enterprise, it is highly efficient. The surgery is the golden ticket. It turns a trivial insurance claim into a multi-million-dollar liability.
Okay, but surgeries are expensive, and these personal injury lawsuits take years to resolve in the New York court system.
Sometimes 5 to 10 years.
So how does this whole machine stay afloat while they wait for the settlement money? This brings us to the final tier of the org chart, the funding defendants.
Yes. The funders are the financial engine of the operation. This is the world of litigation finance.
Right.
Because the claimants are typically impoverished and need money immediately, the funding defendants provide cash advances to the claimants.
And the complaint describes these advances as having usurious rates, just astronomical interest.
Exactly. So the claimant gets a tiny bit of cash up front to keep them hooked. But the funders are doing something much more critical for the machine.
They are bankrolling the medical side.
Yes. The medical providers aren't going to perform complex spinal surgeries for free while they wait 5 years for a lawsuit to settle.
They want to get paid now.
Right. So the funding defendants step in and purchase the medical receivables. They pay the doctors up front for these expensive, unnecessary surgeries.
Wow.
The doctors get their cash immediately, meaning their risk is basically zero. The lawyers get their manufactured medical evidence. And the funders.
They get the right to collect the cost of the surgery plus massive interest out of the final settlement.
It is a closed loop of cash flow.
Let's look at this from a structural perspective.
Yeah.
This whole flowchart, the runners finding the marks, the lawyers writing the script, the doctors providing the special effects, and the funders bankrolling the production, it is perfectly calibrated.
It's an ecosystem designed to manufacture liability out of thin air. And it is incredibly lucrative.
So here is the question that I was screaming at my nights while reading this.
I think I know what you're going to ask.
If Uber and Union Mutual can map this out so clearly in their federal complaints, if they can show exactly how the money moves and who is doing what, how is this not an open and shut violation of RICO?
Right.
I mean, RICO stands for the Racketeer Influenced and Corrupt Organizations Act. It was passed by Congress in 1970 specifically to dismantle the mafia. This entire ecosystem we just described is the textbook definition of an organized crime syndicate.
You are looking at the exact legal weapon the plaintiffs chose.
Civil RICO.
Okay, explain civil RICO.
While most people know RICO from criminal prosecutions of mob bosses, the statute actually has a civil provision. It allows private parties like an insurance company or a corporation who have been injured by a pattern of racketeering activity to sue the enterprise directly.
And it is a powerful weapon, right? There is a massive financial incentive to use it. It's massive. If you win a civil RICO lawsuit, the statute mandates triple damages.
Terrible.
Yes. If the enterprise defrauded you out of $10 million, the court awards you $30 million, plus attorney's fees.
Wow. That's a huge hammer.
It was designed this way deliberately by Congress. They wanted to encourage private companies to act as private attorneys general and help root out systemic fraud. It is meant to be a nuclear option that just bankrupts the fraudulent enterprise.
Okay, so Uber and Union Mutual brought the nuclear option. They mapped out the enterprise. But as the source material reveals, having the weapon in your arsenal and being allowed to fire it are two very different things.
Very different, because pleading a civil RICO case is notoriously difficult. Over the decades, federal courts have established incredibly high, complex barriers for what constitutes a legal enterprise and what constitutes a direct injury.
Right.
But what makes our duck dive today so fascinating is that these barriers are not being applied equally across the country.
And this brings us to the geographic disparity. Let's look at how this plays out in the real world. Because Uber didn't just get hit with these lawsuits in New York.
No, Uber is a global company. They are dealing with this everywhere.
So they took this exact same legal strategy, the civil RICO lawsuit against networks of lawyers and doctors, and they deployed it in different federal districts.
And we have a perfect comparative test case highlighted in the legal memos. Let's look at the Eastern District of Pennsylvania.
Okay.
Specifically, a case presided over by federal judge Mark A. Carney. This was Uber Technologies versus Simon & Simon PC. Uber filed a YKO lawsuit against a Pennsylvania law firm and associated medical providers.
And just to be clear for the listener, the structure of the alleged fraud in Pennsylvania was essentially identical to the allegations in New York, right?
Materially identical.
Yeah.
Personal injury attorneys allegedly directing clients to specific medical providers, the creation of fraudulent medical records, unnecessary treatments to inflate claim values.
And Uber bleeding money to defend against and settle these manufactured claims.
Exactly the same playbook.
So Uber files the suit in Pennsylvania. The defendants, the lawyers, and doctors immediately file a motion to dismiss. They say, "Judge, this is baseless, throw it out." What did the Pennsylvania judge do?
Judge Kearney denied the motion to dismiss. On May 11, 2026, he ruled that Uber's case could proceed into the discovery phase.
Okay, so he let them in.
He did. He didn't say Uber had proven their case, but he said they had met the legal standard to open the doors and start looking for evidence.
Let's break down that legal standard, because it is the hinge upon which this entire anomaly swings. When a defendant files a motion to dismiss at the very beginning of a case, before any evidence has been exchanged, what is the judge actually supposed to do?
The judge is applying what is known as the Rule 12b-6 standard of the Federal Rules of Civil Procedure.
Okay.
Under this rule, a judge is legally required to accept all of the plaintiff's factual allegations as true for the purpose of the motion.
Wait, they have to assume it's all true?
Yes. Furthermore, the judge must draw all reasonable inferences in favor of the plaintiff.
So the judge has to pretend the plaintiff's story is 100% accurate, and then ask, if this story is true, does it violate the law?
Exactly. The Supreme Court established in precedents known as Twombly and Iqbal that a complaint must contain sufficient factual matter to state a claim to relief that is plausible on its face.
Plausible, that's the key word.
Right. Plausible doesn't mean proven. It means the judge looks at it and says, yes, based on these allegations, it is reasonably possible that a Rico enterprise exists.
And Judge Kearney in Pennsylvania said, yes, this is plausible. He recognized that figuring out if the doctor's reports were actually fraudulent and if the lawyers were actually coordinating a scheme requires looking at the internal documents.
It requires discovery. He recognized that it is a factual dispute.
The sources note that similar outcomes occurred in federal courts in California, too. Judges looked at the structure of the alleged fraud, found it plausible under that Rule 12b-6 standard, and allowed the corporate plaintiffs to proceed to discovery.
But then we look at the Eastern District of New York. A case titled Uber versus Wingate, Rosati, Shapiro, Moses, and Halperin. It is the exact same plaintiff. It is the exact same legal weapon.
The structure of the alleged fraud is identical.
Identical. Yet Judge Aurelia E. Merchant dismissed Uber's RICO action entirely on the pleadings.
Wow.
No discovery allowed. Case closed, right there at the starting line.
This is where the legal community's alarm bells start ringing. Because how does a federal judge in New York look at the same type of detailed allegations that judges in Pennsylvania and California found plausible and decide to throw the entire case in the trash?
Right.
How does she justify it? If the law requires her to assume Uber's allegations of a coordinated fraud ring are true, how do you dismiss the case?
By fundamentally recharacterizing the actions described in the complaint. Judge Merchant concluded that much of the conduct Uber alleged the lawyers referring clients to specific doctors, the medical treatments, the litigation financing, she said it plausibly represented, in her words, ordinary business relationships.
Wait, I need to stop you there. Ordinary business relationships.
Yeah.
Are you kidding?
The court looked at the dense web of connections. They looked at the fact that these specific lawyers always sent their clients to these specific doctors,
Who always miraculously found the exact same catastrophic spinal injuries.
requiring the exact same lucrative surgeries funded by the exact same finance companies. And the court said essentially, this doesn't necessarily look like an illegal IOSU enterprise. This just looks like professionals working together in the normal, everyday course of personal injury litigation.
That is, what?
The judge basically said lawyers refer clients to doctors all the time. That's ordinary.
Well, that doesn't track for me at all, based on the rules you just explained. If the judge is legally mandated by the Rule 12b-6
Yeah.
standard to draw all reasonable inferences in favor of the plaintiff in favor of Uber, isn't characterizing these actions as ordinary business, doing the exact opposite.
That is the precise doctrinal friction the legal memos are screaming about.
Let me give you an analogy to see if I have this straight. Let's say we are looking at a classic mob case. A mafia boss hands a hitman a duffel bag full of untraceable cash in a dark alley at 3 in the morning. If we apply the New York court's logic to that scenario, the judge is looking at the duffel bag of cash and saying, well, this could just be an ordinary independent contractor payment for landscaping services rendered.
Exactly. Exchanging cash is a normal business activity.
You're right. The judge is actively selecting the innocent explanation over the fraudulent explanation before any evidence has even been presented.
Your analogy is spot on. The critical comparison document in our sources zeroes in on this exact behavior. It asks, did the New York court select innocent explanations for disputed conduct, rather than determining whether Uber's fraudulent explanation was plausible?
Which is what they're supposed to do.
Right. In Pennsylvania, Judge Kearney said, whether these referrals are legitimate medical care or a fraudulent scheme is a question of fact. We need discovery to figure it out.
And in New York.
In New York, Judge Merchant effectively resolved that ambiguity herself before discovery even started by branding the behavior as ordinary business.
And this brings me to the focus point that we really need to emphasize for you, the listener, because this is the core of why this deep dive matters. We are observing a seemingly uniquely New York problem here.
Yeah, it really seems isolated.
The stark, undeniable difference in how these federal courts are handling identical types of cases raises massive, uncomfortable questions. Now, we have to look at this totally impartially.
Absolutely.
The source materials do not make direct accusations of corruption against the judiciary, and neither are we. But we must look at the practical, real-world effect of this legal philosophy. If the New York federal courts consistently interpret these dense fraud allegations as ordinary business, it creates a structural pattern.
A pattern where practically all massive litigation fraud cases disappear before they even start.
Right. They are suffocated in the crib. And if you take a step back and ask yourself who benefits from a legal standard that makes it impossible to sue a network of lawyers and doctors for fraud, well, it practically benefits only one group.
The trial lawyers.
The trial lawyers who are bringing the underlying injury claims.
It creates an impenetrable shield. If the threshold to prove a complex conspiracy without any discovery is set so impossibly high that no plaintiff can ever clear it, the enterprise is practically immune from civil prosecution in that jurisdiction.
You have built a fortress around the alleged fraudsters.
You really have.
Which begs the obvious question. If the New York judge wants more proof that this is a criminal enterprise and not just ordinary business, why can't the plaintiffs just show her the proof?
Because of the nature of discovery.
Right.
Sophisticated fraud rings, especially ones orchestrated by highly educated lawyers and doctors who know the rules of evidence intimately. They do not leave their master plans lying around in public view.
No, they aren't stupid.
They don't post their kickback agreements on a billboard. The proof of coordination, the actual smoking guns that separate an innocent referral from a corrupt Rico enterprise, live in the shadows.
You are talking about the internal documents, the bank records showing the money flowing between the funders and the doctors, the private text messages between the runner and the lawyer.
The encrypted emails, the confidential litigation funding agreements.
Exactly. None of that is public record.
None of it. The only way to get those documents is through the legal power of subpoena, which you only get during the discovery phase of a lawsuit.
So let's map out this impossible loop for the listener. To get a New York judge to allow you into the discovery phase where you can finally issue subpoenas for the bank records and the text messages you have to prove to the judge in your initial complaint that a highly detailed, deeply connected ROK enterprise exists.
Right.
But to prove that enterprise exists to the judge's satisfaction, you need the very evidence that you are only allowed to get through the discovery phase.
It is maddening. You are demanding the plaintiff produce the murder weapon before you give them a search warrant to look for the murder weapon.
And the Union Mutual decision provides the most stark, almost unbelievable example of this catch-22 in action. Because Union Mutual didn't just give up.
No, they didn't.
They knew they were facing this impossible burden in New York, so they did incredible, exhaustive investigative work before their case was dismissed.
They did. Union Mutual went out and scoured the earth for evidence they could access without discovery, and they found it.
What did they find?
They discovered newly filed public bank records from other entirely separate federal litigations that corroborated the financial ties they were alleging. But even more incredibly, they obtained a sworn declaration from a whistleblower.
Oh, wow.
Yes, a former managing director of one of the medical organizations involved in the scheme. An actual insider.
So they actually found someone from inside the machine willing to testify on the record. That is the holy grail of a fraud investigation.
It really is. They had concrete pieces of the puzzle that almost never see the light of day before discovery begins. They took this newly discovered evidence, the bank records, and the insider's sworn testimony, and they went to Judge Merchant. They begged for permission to supplement their original complaint. They essentially said, "Your Honor, we know you want more definitive proof of the enterprise and the coordination before you let us proceed. Here it is. Here are the bank records and an insider's sworn testimony."
And what did the court do with that evidence?
The court refused to even look at it.
Wait, what?
Judge Merchant denied the request to supplement the complaint, stating that even with this new, explosive evidence, it would be futile.
Futile? How is hard evidence futile?
She ruled it wouldn't cure a completely different legal deficiency in their case, called the statutory standing problem, which is a whole other labyrinth we need to explore.
I really want to sit with the result of that ruling for a second. Potentially corroborating evidence, actual bank records, and an insider's testimony exposing a massive multi-million-dollar medical and legal fraud enterprise was actively blocked from ever seeing the inside of a courtroom.
Yes.
The judge looked at the plaintiff and said, "Even if you hold the proof in your hands, I am not going to allow you to show it to me."
It's hard to believe.
That is a staggering reality for the justice system. It means that even if a plaintiff manages to do the impossible and solve the catch-22 on their own through sheer investigative luck, the courthouse doors can still be slammed in their face on a procedural technicality.
And that procedural technicality is perhaps the most dangerous part of this entire geographic anomaly. To really understand the scale of what happened, we need to look closely at that specific day, August 14th, 2026.
Right. Paint the picture for us.
Yeah.
This is a monumental day in the Eastern District of New York.
On August 14, 2026, Judge Aurelia E. Merchant didn't just issue one massive decision, she issued two.
Okay.
She handed down the dismissal for the Uber case, wiping out their ICO claims, and on the exact same day, she handed down a dense 30-page dismissal for the Union Mutual case.
So two of the largest, best-funded, most comprehensive attempts to break the back of this alleged fraud machine in New York were completely wiped out simultaneously. Okay, we understand why Uber was kicked out. The judge viewed the lawyers and doctors as just having ordinary business relationships, and we discussed the absurdity of that standard. But Union Mutual is an insurance company.
Right.
They alleged a much broader, overarching enterprise involving the runners, the funders, the staged accidents, the entire ecosystem. Why were they dismissed? What was the statutory standing problem the judge used to block their whistleblower evidence?
The fatal flaw for Union Mutual, according to the court, was the proximate cause problem.
Proximate cause. Okay, explain that.
Now, the court agreed that Union Mutual suffered actual tangible monetary injury. They paid out millions in fraudulent settlements. They lost real money.
Says they were definitely harmed.
Yes. That satisfies what is called Article 3 constitutional standing. The Constitution says you have to have an actual controversy, a real injury, to be in federal court. Union Mutual had that. But under the Civil Arsho statute, you also need what is called statutory standing.
And what is the difference?
Statutory standing looks at whether Congress intended for you specifically to be able to sue under this law. And the Supreme Court, in a very famous 1992 precedent known as Holmes versus Securities Investor Protection Corps, severely limited who has statutory standing under IOCO.
Okay, what did the Supreme Court say?
They ruled that for a plaintiff to have standing, their injury must be a direct result of the fraud.
I feel like direct is one of those legal words that means something completely different than its dictionary definition. How does the law define direct in this context?
The history of the Holmes decision is actually rooted in a very practical concern. The Supreme Court was worried about infinite chain reactions of litigation. Think of it like throwing a rock into a pond.
Okay, I'm visualizing a pond.
The splash is the direct injury. The ripples are indirect injuries. If a fraudster bankrupts a company, the company is directly injured. That's the splash.
Got it.
But the company's employees who lose their jobs, the suppliers who lose a client, the local diner where the employees used to eat lunch, they all suffer real financial harm, right?
Sure, they lose money too.
But they are ripples. The Supreme Court said you cannot let every ripple sue under IOCO, or the courts would be completely paralyzed. You cannot be two causal steps removed from the original fraud.
Okay, the logic of preventing an infinite chain of lawsuits makes sense in a vacuum. But how did Judge Merchant apply that ripple in a pond logic to an insurance company that is literally writing the checks to the fraudsters?
The court's logic in the Union Mutual case was this. The fraudsters did not target the insurance company directly.
Who did they target then?
The fraudsters targeted the claimants by recruiting them and performing fake surgeries on them. And the fraudsters targeted the property owners by naming them as the defendants in the fraudulent state court lawsuits.
Okay.
The insurance company Union Mutual was only injured because they happened to hold an insurance policy for the property owners who were the ones actually sued.
That is, I mean, what kind of mental gymnastics is that?
Therefore, the judge ruled Union Mutual is an indirect victim. They are a ripple. They are too far down the chain of causality. They lack proximate cause, and therefore they have no legal right to use the RICO statute.
I want to take a step back and map out the terrifying real-world implications of this legal framework. Let's look at this loophole, or really, this legally constructed safe harbor that has been created in the Second Circuit.
It is a massive loophole.
Because if we follow the New York court's logic to its natural conclusion, let's look at who is actually allowed to sue these fraud rings. Let's go group by group.
Okay.
Group 1, the claimants. The people who were recruited by the runners and cut open by the doctors. The court says they are the direct targets of the physical fraud. Can they sue the enterprise?
Theoretically, yes. They have direct standing. But practically, absolutely not.
Why not?
The claimants are, by the complaint's own definition, impoverished, non-English speaking, highly vulnerable individuals. They do not have the millions of dollars in legal fees or the sophisticated legal know-how required to mount a massive multi-year civil RICO lawsuit in federal court against a syndicate of high-powered trial lawyers and surgeons.
Right. The very nature of their vulnerability makes them incapable of fighting back.
Exactly.
Okay, so the claimants are out. Group 2, the property owners. The small businesses or homeowners where the fake slip and falls took place. The court says they are direct targets because their names are on the fraudulent lawsuits. Can they use RICO to fight back?
Again, theoretically, yes, they have standing.
Mm.
But in reality, they have zero incentive to sue.
Because of insurance.
Exactly.
Yeah.
Because they have liability insurance. When a property owner gets sued for a slip and fall, they don't hire a lawyer. They just hand the lawsuit over to their insurance company.
The insurer pays for the defense lawyers, and the insurer pays the $1 million settlement.
Right. The property owner isn't out of pocket for the massive damages, so why would they spend 10 years of their life and millions of dollars of their own money fighting a complex federal RICO case? They wouldn't.
So the property owners are out. Group 3, the liability insurers, like Union Mutual, the entities whose money is actually being stolen to fund this entire multi-million-dollar operation.
And as we just discussed, the court explicitly ruled they cannot sue.
Wow.
Under the strict interpretation of the Holmes precedent, they are considered too remote. They lack statutory standing.
So the insurers are legally banned from suing. That leaves us with Group 4 direct corporate targets. Companies like Uber. Uber is a massive corporation, and in many of these cases, they are self-insured or have massive deductibles. That means when a fake accident happens in an Uber, Uber is directly paying the defense costs and the settlements out of their own corporate bank accounts.
Yes, they are.
They are the direct targets, and it is directly their money. Surely they can sue.
We just spent the first half of this deep dive discussing what happens to Uber. Even if they clear the standing hurdle, because they are the direct financial target, their cases get dismissed at the pleading stage because the New York judge views the complex, coordinated actions of the lawyers and doctors as ordinary business activity.
Right. And because of the discovery catch-22, Uber is never allowed to prove otherwise.
Exactly.
Let me give you another analogy, because the ripple in a pond idea is way too gentle for what is happening here. What we are describing is a brilliantly planned bank robbery.
Okay, let's hear it.
Imagine a crew of bank robbers walks into a bank, holds up the place at gunpoint, and walks out with duffel bags full of cash. Under this specific New York legal framework, the tellers who were held at gunpoint can't sue the robbers because it wasn't their personal money that got stolen. They don't have the resources anyway.
Right, they are like the claimants.
The bank president can't sue the robbers because the bank's vault is FDIC insured, so the bank didn't actually lose any of its own money.
They are the property owners.
And the insurance company that ultimately writes the check to cover the stolen cash is legally barred from suing the robbers because they weren't physically standing in the room when the robbery happened. They are, quote-unquote, too remote.
It is a profound analogy because it perfectly illustrates what the source document calls the RICO enforcement gap.
The enforcement gap.
Yes.
Yeah.
It reveals the structural absurdity of combining all of these strict legal interpretations. If all of these doctrines, the Holmes indirect injury rule, the ordinary business assumption at the pleading stage, and the impossible discovery catch-22, if they all hold true simultaneously, the federal court system in New York has accidentally, or perhaps fundamentally, created a practical safe harbor for sophisticated litigation fraud.
Literally no one is allowed to sue the fraudsters. The victims with the motivation and the financial resources to fight back the insurers and the corporations are legally disarmed by the court.
Yes.
The victims who are legally permitted to fight back the claimants and the property owners lack either the money or the motivation to do so. It is the perfect crime, sanctioned by procedural roadblocks.
And if you think that perfect crime scenario is bleak, it is actually compounded by one more legal hurdle.
Oh, there's more.
There is one more trapdoor that Judge Merchant utilized to dismiss the Uber case, which shows just how deeply entrenched this enforcement gap really is.
Right, let's go back to Uber, because I asked earlier why Uber was dismissed, and we talked about the ordinary business excuse, but there was another major flaw the judge found in Uber's case, wasn't there?
Yeah.
Union Mutual was an insurer, so they were too remote. But Uber was the direct target. They were the name on the lawsuit. They were the ones writing the checks to their defense lawyers to fight these fake slip and falls. The money was actively leaving Uber's bank account. Why wasn't that enough of an injury to justify the lawsuit?
Because of a constitutional legal concept called the ripeness doctrine, which is specifically applied to Ryan Go as the requirement for a clear and definite injury.
Okay, explain the ripeness doctrine.
It stems from Article 3 of the Constitution, which says federal courts can only hear actual cases or controversies. Federal courts do not issue advisory opinions, and they do not let you sue for things that might happen in the future.
Right.
Under the RICO statute, this means your financial loss cannot be speculative. You can only sue for money. You have definitely, permanently lost. Your injury must be clear and definite.
That makes perfect sense on the surface. You shouldn't be able to sue someone for a hypothetical loss. But Uber wasn't dealing with hypotheticals.
No, they weren't.
They had already spent the money. They were paying high-priced defense lawyers every single month to fight these fraudulent claims in state court.
Yes, they had incurred massive defense costs. But the judge looked closely at the specific examples Uber provided in their complaint. To prove the pattern of racketeering, Uber listed 5 specific state court personal injury cases as examples of the fraud.
Okay, what was wrong with the 5 cases?
Here was the fatal flaw. 3 of those 5 state court cases were still pending. They hadn't gone to trial or settled yet. Because the underlying lawsuits hadn't finished, Judge Merchant ruled that Uber's damages were not yet final. Therefore, the injury was not clear and definite.
I have to push back on this on behalf of basic human logic. Uber already paid the defense lawyers. The checks have cleared the bank. The money is gone. How is that not a definite injury?
I know, it sounds crazy.
If someone forces me to hire a lawyer to defend myself against a completely fabricated, fraudulent lawsuit, the money I pay my lawyer is a real, tangible, devastating loss right now.
The federal court's reasoning, and to be fair, they do cite Second Circuit precedent for this, is that the final mathematical calculation on Uber's losses isn't done until the state court cases are completely over.
How does that matter?
The court reasoned that Uber might win those pending cases in state court, or Uber might countersue in state court and get sanctions against the fraudulent lawyers, meaning the state judge might order the fraudsters to pay Uber's defense costs back.
Oh, I see.
Because those theoretical possibilities exist, the federal court says the damages are subject to change. Therefore, the RSEO claim is premature or, in legal terms, unripe.
I want to make sure you, the listener, grasp the sheer Kafkaesque absurdity of this trap. Imagine you are a company being actively bled dry by a syndicate.
Bleeding millions.
They're filing hundreds of fake lawsuits against you. You are hemorrhaging millions of dollars in legal fees just to defend yourself from completely fabricated claims. You go to federal court for help, and the judge tells you that you are not allowed to sue the syndicate for fraud until they finish bleeding you.
Until every single case is closed.
You have to wait until every single fake lawsuit is resolved. And we were talking about the New York State court system where a personal injury case can easily take 5 to 10 years to go to trial.
Easily.
The federal court is demanding that you wait a decade before your injury is considered definite enough to fight back.
And the practical reality of waiting 10 years is that you will never get your money back.
Because the money will be gone.
Exactly.
Yeah.
By the time those state cases resolve, the fraudsters have long since taken the settlement money from the other cases, dissolved their shell companies, hidden the assets in offshore accounts, and moved on to the next racket. The money is gone.
Wow.
By applying the ripeness doctrine, this strictly to ongoing litigation fraud, the court is essentially demanding that the victim endures the entire duration of the abuse before they are allowed to ask for help. And by the time they are allowed to ask for help, the abusers have vanished.
It is a labyrinth of impossible standards. Think about the maze a plaintiff has to navigate in New York. If you sue too early, you get dismissed for not having a clear and definite injury under the ripeness doctrine.
Right.
If you wait until the injury is definite, the criminals are gone. If you are an insurer trying to protect the system, you get dismissed for being too remote under the proximate cause doctrine. If you are a direct target who tries to prove the conspiracy, you get dismissed because the judge assumes it's ordinary business. And if you try to get the evidence to prove it's not ordinary business, you are denied discovery. Every single path leads to a locked door.
Which is why we desperately need to pull back from the micro-level legal doctrines
Yeah.
and look at the macro-level reality.
Yeah, we have to look at the big picture.
We have to ask, how did the New York federal legal system get to a place where it has constructed this impenetrable, multi-layered labyrinth protecting organized fraud? Why are these judges interpreting these flexible legal standards in the most restrictive, plaintiff-hostile way possible?
And this is where we transition to the broader cultural and political atmosphere in New York. This is where we bring in the op-ed by Damian J. Caldwell titled, "When the Bench Stops Listening."
This piece is so revealing.
It is. Caldwell is voicing what everyone in the insurance and corporate defense world is whispering behind closed doors. He's trying to explain the why behind the what.
Caldwell's core synthesis is fascinating. He argues that there is a growing, pervasive perception within the industry that New York courts do not view civil fraud allegations as a righteous crusade for truth.
What do they view them as?
Instead, they view them as a massive administrative inconvenience.
An inconvenience. That is a chilling word to use when talking about billion-dollar criminal enterprises. But explain what he means by that.
You have to look at it from the perspective of a federal judge operating in the Eastern or Southern District of New York. These are some of the most backlogged, overwhelmed, intensely busy court systems in the entire country.
The caseloads are insane.
The sheer volume of cases is staggering.
Yeah.
And civil RKO cases alleging systemic fraud are incredibly messy. They are the absolute antithesis of judicial efficiency.
Why are they so messy?
If a judge allows a massive RK case to survive a motions to dismiss and proceed to discovery, they are signing up for years of administrative hell. They're going to have to oversee the subpoenaing of millions of pages of bank records.
Right, the discovery phase.
They're going to have to referee endless disputes over attorney-client privilege regarding the law firm's internal communications. They will have to oversee depositions of dozens of doctors and hire independent medical experts to argue over the nuances of hundreds of different MRI scans.
It's a full-time job.
A single IKO case can clog up a judge's docket for half a decade.
So, from a purely administrative standpoint, it is infinitely more efficient for a judge to look at the complaint, apply a hyper-strict interpretation of the Holmes precedent or the ripeness doctrine, dismiss the massive Rico case on the pleadings, and just get it off their desk forever.
Exactly. Caldwell suggests that the pressure of docket management creates a subconscious, or perhaps even conscious, judicial bias toward dismissal. It is the prioritization of efficiency over the agonizing, time-consuming pursuit of systemic justice.
But Caldwell points to something else, too. Something much more localized to New York, the political optics. And I want to navigate this very carefully.
Yes, it's a sensitive topic.
We are remaining totally impartial as we discuss the source material. Caldwell points out a structural reality of the New York state legal and political system. While federal judges are appointed for life, they exist within an ecosystem deeply influenced by state politics.
And state politics are very different.
New York State relies heavily on judicial elections for its local courts, and its legislature is intensely lobbied. Historically, one of the most significant, well-funded, and organized political forces in New York State politics are the trial lawyer organizations and their associated political action committees.
It is crucial to emphasize the nuance here. Neither Caldwell nor the source documents, nor are we alleging direct corruption.
No, absolutely not.
No one is saying federal judges are taking bribes in back rooms to dismiss these cases. There is zero verifiable evidence of any quid pro quo.
Right. We are absolutely not alleging corruption. But Caldwell's point is not about bribery. It is about atmosphere. His point is that perception matters.
Yes, exactly. The trial bar in New York holds immense political sway. They shape the laws. They fund the campaigns. They are a dominant force in the legal culture.
And how does that affect the federal courts?
When the insurance industry and corporate defendants watch massive fraud claims repeatedly, systematically die in New York federal courts on procedural technicalities, especially when those exact same claims sail through the federal courts in Pennsylvania and California, public confidence in the impartiality of the judiciary collapses.
It looks bad.
It creates a toxic atmosphere where litigants feel the game is structurally rigged before the opening whistle is even blown.
And Caldwell highlights an incredible, almost painful cognitive dissonance in all of this. If you listen to New York state lawmakers or the New York Department of Financial Services, they constantly talk about fighting insurance fraud.
all the time.
The state has dedicated fraud bureaus. District attorneys set up high-profile task forces. Federal prosecutors in New York occasionally bring massive criminal REK cases against medical mills with perp walks and press conferences. The public posture of the state is vehemently tough on fraud.
Yet when private companies, the entities who are actually bleeding the money, who are intimately familiar with the mechanics of the fraud, try to use the civil court system to fight that exact same fraud, the civil judges seem to bolt the doors shut.
Right. The criminal justice system is waving the flag and declaring war on fraud, but the civil justice system is putting up a brick wall and protecting the perpetrators.
It's a huge disconnect.
And this is the focus point I really want to hammer home as we begin to wrap up this incredibly deep dive, because this is the most vital distinction you need to understand about what happened on August 14th, 2026.
Yes, this is key.
By establishing a pleading threshold that is practically impossible to meet, by requiring smoking gun evidence before allowing discovery, by defining insurers as too remote to sue, by demanding that ongoing fraudulent cases be completely finished before they count as an injury.
All of those hurdles.
The New York federal courts are not ruling that the fraud didn't occur.
That is the tragedy of this situation. Judge Merchant did not issue a ruling saying Uber and Union Mutual were lying. She did not issue a ruling exonerating the Subin firm or Wingate or Dr. Gerling.
Right.
She did not say these medical procedures were legitimate.
The courts are simply ruling that plaintiffs cannot use the federal civil courts to pursue the truth. They are looking at mountains of circumstantial evidence, and in the case of Union Mutual, actual whistleblower evidence, and saying, the fraud might be happening, it might be costing billions of dollars, but you are not allowed to use my courtroom to stop it.
That's essentially it.
This uniquely New York problem creates a de facto immunity shield for bad actors. And we have to ask again who pays for it, because the money doesn't just disappear.
No, it has to come from somewhere.
Everyone who pays an insurance premium pays for it. When the liability insurers lose billions of dollars to fake slip and falls and unnecessary spinal fusions, they don't just politely absorb the loss, they recalculate their risk models.
They raise the rates.
They raise the rates on every single driver, every single homeowner, and every single small business in the state of New York.
It is a hidden tax on the entire population, facilitated by a judicial doctrine of avoidance. The courts are protecting their dockets, and in doing so, they are protecting the enterprise.
Let's take a breath and quickly recap the massive journey we have just been on. We started by looking at a sprawling, industrial-scale fraud machine.
The runners finding the vulnerable, the lawyers directing the narrative, the doctors performing the unnecessary surgeries, and the funders keeping the cash flowing.
We looked at a tale of two vastly different judicial approaches. We saw a federal judge in Pennsylvania say, this looks plausible, let's look at the evidence, while a federal judge in New York looked at the exact same allegations and said, we assume this is just ordinary business.
We unraveled the impossible catch-22 of discovery, where you need the proof to get the proof, and saw how even finding a whistleblower wasn't enough to open the courthouse doors.
And we mapped out the legal enforcement gap created by the Union Mutual and Uber decisions. We saw how the rigid application of the Holmes proximate cause doctrine and the ripeness doctrine has created a labyrinth that seemingly immunizes sophisticated fraudsters in the Second Circuit from any civil accountability whatsoever.
And as we close this deep dive, I want to leave you with a chilling final thought to mull over.
Okay, what is it?
We talked earlier about how the IRA co-statute was originally designed by Congress to take down traditional, violent, organized crime, the mob, La Cosa Nostra.
The families that ran extortion, illegal gambling, and loan sharking.
Exactly. Well, if the civil courts in New York have effectively disarmed the victims of insurance fraud by making civil IRA code claims impossible to plead, how long will it be before traditional organized crime syndicates realize that they are in the wrong business?
Oh, wow. That is a terrifying thought.
Why would a criminal syndicate risk going to federal prison for a violent extortion racket or run a high-risk illegal gambling ring when the most profitable, entirely risk-free racket in town is simply opening a personal injury law firm and a medical clinic in Brooklyn?
Right. Why use a crowbar to rob a bank when you can use a scalpel and a subpoena to legally extract millions from an insurance company?
Exactly. If the civil justice system flat out refuses to look at the evidence because of procedural hurdles, and if the standard for proving fraud is set so high that it can never be met, the perfect crime might not be a diamond heist.
What would it be?
The perfect crime might just be a well-documented slip and fall.
When the systems designed to uncover the truth refuse to even look at the evidence, the sickness just keeps spreading in the dark. Thank you so much for sticking with us through this extended, deeply complex deep dive. We know it was a massive amount of dense legal information, but understanding these structural legal mechanisms is how you understand how the hidden machinery of the world actually works. Keep questioning the systems around you, keep looking for the loopholes that govern your life, and we will catch you next time.